Welcome back to the video lecture on Asian state practice in the domestic implementation of international law. This time, we are going to talk about island territorial claims, law of the sea disputes, joint development initiative, and innocent passage regimes as a classical example of the issue. Let me first touch upon the colonial legacies and island territorial claims. The colonialism has cast a long shadow on the development of international law in the Asian states. Many colonial empires expanded into Asia through the signing of bilateral treaties, many of which were very unequal. For example, the unequal border treaty signed between Qing Dynasty and Tsar Russia became the basis for the demarcation of the land boundary between China and Russia in the 1990 years. For Japan, the first formal colony out of the inherent territory was Taiwan. By the Treaty of Shimonoseki of the 1895 between Japan and China, at the time Qing Dynasty, after Sino-Japanese War, China ceded Taiwan to Japan. Also, the effects of the Annexation Treaty of the 1910 incorporates and annexes Korea to Japan. Many former colonies have successfully become independent states. However, many disputes remain that existed under the shadow of the colonial period. Some territorial disputes are still unresolved. For example, first, Dokdo Takeshima sovereignty dispute between Korea and Japan. And second, the Ayudai, the Senkaku Island sovereignty disputes between China, Japan, and Taiwan. And third, Spratly Island in the South China Sea sovereignty disputes between Brunei, China, Malaysia, the Philippines, Taiwan, and Vietnam. And fourth, legal status of the North Borneo, which is the Sabah, between the Philippines and Malaysia. The legacies of the colonial era regarding territorial sovereignty and location of the international borders are evident in South Korea, Indonesia, Timor-Leste, Malaysia, Singapore, Bangladesh, India, Pakistan, with Thailand standing out as never being decolonized. Let me talk about the approach to settlement of the law of the sea dispute. An important area for the practice of international law is the method adopted to settle dispute between states. In the field of law of the sea, including overlapping or the conflicting jurisdictional or the territorial claims, there are a number of mechanisms available to resolve disputes. Some states in Southeast Asia have demonstrated confidence in such mechanisms by agreeing to submit disputes to formal third-party dispute resolution. The key cases concerned sovereignty of insular features and maritime boundary delimitation is, for example, the Malaysia-Singapore, the ICA decision in 2008 in terms of the Petra Branca, Pulau Batu Bite. And second, between the Bangladesh and Myanmar in 2012 at ITLOS in terms of a maritime boundary delimitation. And third, the Bangladesh-India in 2014, the case referred to Permanent Court of Arbitration in terms of the maritime boundary arbitration. Other cases were initiated under the compulsory disputes, the resolution mechanism in the UNCLOS. The first, India-Italy in 2015 at ITLOS about maritime criminal jurisdiction, and second, Philippines and China in 2016 referred to ITLOS, which is about South China Sea, whether the case is that China is become a non-participant. Further, there are oil platform disputes were litigated in International Court of Justice in 1996 between Iran and the United States. It is noteworthy that the formal dispute resolution mechanisms have not been initiated for disputes in Northeast Asia, despite many disputes existing, ranging from sovereignty, maritime boundaries, the fisheries, and enforcement jurisdiction. China in particular has emphasized its preference to resolve disputes by dialogue rather than compulsory binding third-party resolution, which is non-participation and non-acceptance of the 2016 award with the Philippines. Taiwan's unique international status is an obvious impediment for the government in Taipei to participate in interstate disputes. There are also no cases concerning South Korea-Japan, although the Japanese government has suggested the Japan-Korea sovereignty disputes over Takeshima Dokdo Takeshima, should be submitted to the International Court of Justice. Asian state has also demonstrated considerable capacity to settle maritime boundary dispute and jurisdictional issues peacefully, including by way of the cooperation. For example, in Central Asia, the 5 states in Azerbaijan, Iran, Kazakhstan, Turkmenistan, and Russia concluded the regional convention on the status of the Caspian Sea. The numerous maritime boundary agreements has been concluded, such as Iran and Bahrain, India with the Maldives and Myanmar, Sri Lanka and Thailand, and China and Vietnam. The limitation in the Gulf of Tonkin between China and Vietnam contribute to state practice in settling on a single line for both the continental shelf and the EEZ between states with opposing coasts. Similarly, in a practical problem in the law of the sea is where more than one country asserts maritime jurisdiction over the same area. There are numerous areas that where overlapping jurisdiction exists. This problem can be avoided in the state in question can agree on an equitable solution to limit maritime boundary. Where this cannot be achieved, the overlap of the asserted jurisdiction will persist. Asian states have demonstrated willingness and capacity to put aside maritime boundary disputes by working out a practical solution. This is by use of the Joint Development Area, so-called the JDA, whereby a large area is identified for cooperation in activities or maritime exploitation. This approach effectively serves the seemingly impossible problem of agreeing on a precise maritime boundary while allowing the marine activities to occur in a situation of shared understanding and mutual benefits. Malaysia has agreed joint development areas with Thailand, for example, customs enforcements on the continental shelf beyond the territorial sea, and Vietnam in terms of the petroleum operations. Other areas of the cooperation are apparent, such as the fisheries enforcement cooperation in the case of the China, South Korea, and China, Japan, and South Korea and Japan, China, Vietnam, and also Taiwan and Japan in the Taiwan and Philippines, as well as cooperation in other fields, for example, China, Korea, China, Japan and Korea, including an agreed the prior notification regime between China and Japan for marine science research in the East China Sea. A key area where the joint development areas could be useful in the South China Sea due to the multiple overlapping claims. China has been a strong proponent of the JDAs since the leadership of Deng Xiaoping in the 1990s. This position is also supported by the government of Taiwan. An early JDA was agreed between Japan and Korea in 1974 concerning the development of the continental shelf. This agreement contributes to the international acceptance of this model of dealing with the complexity of overlapping maritime claims and the expectation of the meaningful negotiation between states. Nevertheless, in some areas, JDA proposals are fraught with the difficulties, such as a muted JDA between North and South Korea. Let me touch upon the innocent passage regimes. The nature of the right of the innocent passage is a result of the compromise between exercise of the freedom of navigation of navigating states and the jurisdiction of the coastal states. In other words, On the one hand, it is general obligation to respect that ships of all states, whether coastal or the landlocked, enjoy the right of the innocent passage through the territorial sea. On the other hand, for certain ships, such as foreign nuclear power ships and the ships carrying nuclear or other inherently dangerous or noxious substance, should meet certain conditions or requirements when passing territorial waters and exercising rights of innocent passage. Another example is that UNCLOS stipulates that coastal state may specifically request foreign oil tankers, nuclear-powered ships, and the carriage of the nuclear materials to confine their passage to sea lanes. In addition, submarines and other underwater vehicles are required to navigate on the surface and to show their flag. In treasures considerations, national security concepts are observed from the perspective of national defense. In other words, they are about military activities. However, in modern times, where international affairs are highly differentiated, there is a tendency to emphasize a security consideration with diversified connotation and forms. Therefore, it should also include other non-defense considerations, such as economic, political, social, environments, and also the cultural matters. It is the so-called comprehensive security. In peacetime, civilian ships of other countries can enjoy their rights to pass the territorial waters of other countries, provided by they meet the requirements of the innocent passage in accordance with the UNCLOS. However, whether a foreign warship could enjoy the right of the innocent passage into territorial waters of other states is still controversial in academic discussions and in state practice, especially in Asia. For the practice of the Asian states, whether foreign warships can enjoy the right of the innocent passage through the territorial waters of other states is divided. The majority of the Asian states would like to add the various conditions for foreign warships exercising right of the innocent passage in their territorial seas. These conditions could be categorized into the following practices. For example, the first, prior authorization or prior permission is needed. For example, Bangladesh, China, Iran, and Sri Lanka. And second, a prior notification is needed. For example, India, Korea, Malaysia, Philippines, Taiwan, and Vietnam. And third, foreign warships are entitled to exercise right of innocent passage. For example, Japan and Thailand. Based on the above observations, it seems a general practice for Asian states to impose additional conditions for foreign warships in case they would like to exercise rights of the innocent passage through the territorial sea of other states. Thank you very much for your very kind attention.